Hello and welcome back to the East Carolina Law Group. My name is Attorney Tim Koller. I'm the Principal Attorney at Law here. We're located in beautiful Caratoke County. We're about 20 minutes south of the Chesapeake, Virginia border, about 20 minutes north of the Outer Banks, and about 20 minutes east of Elizabeth City. The East Carolina Law Group's been here for about a year, and we have a very dynamic practice. And today, in this portion of our video series, we're going to be discussing personal injury. So what is personal injury? What does that encompass? Generally, what personal injury encompasses is negligence claims. Negligence claims are something that get a lot of bad press, however, are very, very important because many times people will say, oh, that person's just out for money and that sort of thing. But what most folks don't realize is that if you're filing a negligence claim, particularly if you have a good recovery, it's usually because this person has suffered a pretty egregious injury as a result of somebody else's negligence. The important thing about negligence to understand for the common person who's not an attorney is you don't have to intend for something bad to happen in order to be guilty of negligence or liable in negligence. Negligence requires that the tortfeasor or the person who did the bad thing simply has a duty to the person that was injured, that they breached that duty in some way, and that breach of duty was the actual and proximate cause of an actually sustained injury. Now, what this means is a lot of folks have a disconnect when it comes to the duty component. What is your duty? We'll put this in the context of a motorcycle accident, because one of the things that we do a great number of is motorcycle claims. A lot of times people will say, well, that I didn't owe that person any duty. Well, you do. Many times what we have is we have claims with what I call KGV Motorcycle, meaning a car against a motorcycle. And in those situations, we'll talk to the other side and they'll say, well, I didn't mean for this to happen. Well, nobody means to wake up in the morning and injure somebody, but sometimes things do happen. And what this generally means is that you owe a duty anytime you get on the road to protect those around you and to drive in a careful and responsible manner, a reasonably prudent manner. For example, if you're one of the millions of people who drive and text every day, you are breaching your duty to other motorists. Now, if you are driving and texting and you hit a motorcycle operator, you have breached your duty of reasonable care. That breach was the actual and proximate cause, foreseeability being the operative word, of the injury sustained by that person on the motorcycle. Now, when you're dealing with a cage v cage, meaning car versus car situation in a personal injury accident, it's oftentimes easy enough to get into a negotiation on injuries and actual damages because cars generally can sustain a lot more damage with a lot less injury to its occupants than a motorcycle. But most often, if you strike a motorcycle, you're going to end up in a very bad situation where your insurance is going to be paying out a lot of money and potentially there may be an excess judgment. So if you're one of the millions that are out there texting and driving, you owe a duty of reasonable care to protect those around you. By being distracted and text messaging, you're breaching that duty. And if you hit somebody in another car or on a motorcycle while you're text messaging, it is reasonably foreseeable that you will end up in an accident because you are distracted, and if that results in an actual injury, you are liable. And that's all it takes. You don't have to intend to. I didn't mean to harm that person. Intent doesn't matter. It's negligence. Do you owe a duty? Did you breach it? So that's the important thing to remember about a personal injury claim. It is a duty owed, a duty breached, a foreseeability analysis as to whether it was foreseeable that the breach of duty could cause injury, and whether that was the actual and proximate cause of the injury, and was there an actual injury. There must be an actual injury. Now, many times I do get cases where I get people that will come in that will say, this person hit me, my car's a little messed up, I'm okay, but they should pay. And unfortunately, usually what I'll tell them is, look, you can hire me to represent you on a contingent fee of 1/3, and I can probably get you a little bit of compensable medical if you have actual medical problems, but I'm probably only going to be able to get you some property damage. And in reality, any good attorney is going to tell them that. Because unlike some of the television attorneys and attorneys with some of the more flamboyant commercials, you can only do but so much. Now, the important thing to keep in mind and remember anytime you have any kind of a personal injury claim is whether you should handle this on your own. And we keep coming back to whether you should represent yourself. And one of the biggest things that I find that people try to represent themselves on is personal injury claims. And the thing that you have to remember is this. One, unless you have a working understanding of the actual elements of negligence and the elements, the sub-elements within the causation and damages portion of such a claim, you are probably not going to be able to competently represent yourself. And I've seen many cases where people have come to me and said, oh, I did such a great job and I got this claim settled and I got $5,000 out of the insurance company. I didn't have to give any to an attorney. And you talk to them a little bit and you realize they probably could have gotten about $50,000 out of that insurance company had they hired an attorney. Even with giving an attorney 1/3 of that recovery, they would have still come out myriads ahead of where they did. The reason you hire an attorney to handle such a claim is because we know how to work insurance companies, we understand the elements, and we understand what things are compensable and what are not, and we also understand how the claims process works. You cannot understand all of these things as the common person, as a pro se person, unless you have an extensive background in both insurance and law. You have to understand how that works. You have to know what things the insurance company is required to give you rather than what they're not required to give you. Because that right there is the stepping stone to knowing where you're starting from. So it's important to understand that if you are involved in an accident, particularly if you're involved in a motorcycle related accident, contact an attorney. And if you're involved in a motorcycle accident, contact an attorney that understands the complexities of motorcycle claims, because motorcycle claims are different from car claims. It's a very important distinction. Now, there's other types of personal injury claims out there. For example, wrongful death. If your loved one was killed due to the negligence of another, then you may have a claim for wrongful death. And it's important that you engage an attorney very quickly because the statute of limitations on a wrongful death claim is shorter than on an ordinary negligence claim. So you need to make sure you get an attorney involved soon. Secondly, you need to make sure that whoever the decedent was, the person who was killed, has an estate that's been opened. Because an attorney cannot even begin a case without an open estate because their job is to represent the estate. So, as it relates to personal injury, remember, rule number 1, get insurance information for the other party. Rule number 2, never, ever, ever offer to pay damages out of pocket. You have insurance for a reason. It's kind of like hiring the mob to watch your back. You don't like it, you don't like paying it, but you're darn glad when you got it and you need it. Don't ever offer to pay claims out of pocket trying to save your monthly premiums. All you're doing is hurting yourself. Number 3, hire an attorney to work your claim. And then number 4, don't ever make any statements on scene that would otherwise hurt your claims. And one thing I would like to reiterate and point out, as I said previously, is that motorcycle claims are very particular to motorcycles. They offer various different sets of issues and circumstances and factors. And one thing I do want to indicate and point out that everybody that's watching this is the East Carolina Law Group is a firm that's founded and operated by bikers. All of our attorneys here ride, and we understand exactly what it is that bikers face every day on open road when you got a bunch of cages around you and people texting and driving and not paying attention. So come on and give us a call. We'd be happy to work with you, and hopefully we'll see you, and hopefully you'll never need us, but if you do, we're here for you. Thank you for tuning into the East Carolina Law Group, where your family is our priority. You can find us on the web at www.eastcarolinalaw.com. You can find us on our Facebook page at the East Carolina Law Group. You can also call us at 252-453-2273. And if you want to find more videos and keep updated on when we put some more of these kind of things up for some more self-help kind of information, you can do so by subscribing to our YouTube channel by clicking on the link right about here. It's there. Down. Yes, right there. Subscribe by clicking our link. Thank you for tuning in. I hope you found this informative, and have a great day.